All right, welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. When I call your name, please say present or here. Bradley Copeland. Here. Jacavian Jackson. Jaquavian Antron Jackson. Will you call the hallway for Mr. Jackson?
No, you're wrong.
Benjamin Miles. Benjamin Ray Miles.
Benjamin Miles. Yes, Your Honor.
Hayden Mitchell.
Here.
David Pesnell. David Pesnell.
David Pesnell. No, Your Honor.
Colby Stepka.
He's present in the hall.
Thank you, Ms. Rowland. Eugenio Gonzalez Merlo, waiver of arraignment file approved, pretrial set March 7th in both causes, CR 22-374 and 375. Randa Boaz.
Your Honor, I'm the present part. She is not here yet. I don't expect her to be here on the day of that. She has a blue one. And I'm sure she knows what, so I just take her being here. I'll hang around to her.
Okay, thank you, sir. Joshua Lee Davis, CR 22-372. It's been verified in custody in Smith County. Is Mr. Lambert here?
Mr. Lambert. Okay.
No. Charles Bennett.
Charles Bennett. No, Your Honor.
James Bustamante. Thank you, sir. Joseph Cronin. Nash Fuller.
He's in custody.
Robert Gerard. Kenneth Henderson. Kenneth,
Yes, Your Honor.
thank you. Jeremy Hester.
No, Your Honor.
Sydney Hip.
Sydney Hip. Yes, Your Honor.
Nathan Cappill.
There.
Anthony Murray.
There.
Jennifer Rollins.
Here.
Michael Tuff.
He's after.
Katie Williams.
Katie. No, Your Honor.
She should be on her.
Kenesha Williams.
I spoke to her this morning. She is on her.
Sandra Fletcher.
Yeah.
Daniel Payne.
There.
Mary Robinson. For the record, on the docket is cause number CR 21-372, State versus Debbie Spriggs. The state has filed a motion to dismiss. The court has signed that and it's being removed from the docket. Jesse Epperson.
No, sir,
Oh.
11.
11 o'clock, okay.
Your Honor, Jacobian Jackson is just, correct.
Okay, thank you. All right, is there anyone who's present and your name has not been called? We checked the hallway, see if there's anyone who's present.
Okay.
Katie Williams this week.
They called me. Yeah. No, you're on.
Okay, we have any attorneys that are ready?
I'm ready, Your Honor.
Ready, Mr. White?
Yes, sir.
Mr. White, who do you have? Because I don't show you on the docket.
Had Senator Fletcher.
Oh. I see it now, okay. All right, Ms. Fletcher, if you'll step up, CR 22-272, Ms. Fletcher, step for docket call.
Your Honor, I talked with the state on this. I'd asked Ms. Heisler to do a couple of things. She's in the process of doing that. I believe the state would join me, asking the court to extend us another docket call. I think that would be beneficial. And that's going to resolve.
That's right, Your Honor.
Okay. Court will grant an additional docket call to Ms. Fletcher. 30 days sufficient, Mr. White?
I would think so.
You available on Tuesday, March 7th?
Yes, sir.
All right, Ms. Fletcher, the court's going to set you for an additional docket call on March 7th at 9 a.m. in this courtroom. Once you sign and get the yellow copy, you're free to go.
Ms. Fletcher, for you.
Free to go, yes, sir.
Thank you.
Who you want next?
Mr. Payne, Your Honor.
Daniel Payne, CR 22-246.
Yes, Your Honor.
Come on up here with Mr. White. All right, Mr. Payne is set for pre-trial, Mr. White.
Your Honor, we don't have any contested matters at this time. We'll abide by the court's standing order. With those discussed, court we just over the docket call. Just preemptively, I think 30 days would be okay, but we're trying to get some records to say Mr. Payne's a veteran, and so you know, sometimes VA, but we've already got quite a bit of. I'm not sure that we'll know that.
Okay. All right, court will set Mr. Payne for docket call on March 7th. We'll be in this courtroom.
Mr. Payne,
Free to go. You ready, Ms. Robinson?
I am.
Ms. Robinson, CR 22-194, docket call.
Your Honor, I spoke with Ms. Curry and Mr. Woodwhack. Upon a review of the case file on this, I think that there's some additional information that possibly Trooper Cosper has that he had provided, and I asked the state to check into that. There's some witness statement that I believe was done on the telephone, and in my additional round of discovery, I wasn't provided those. I asked him to check on that to make sure, because the report would indicate that at least two possible witnesses were interviewed, and Mr. Woodwhack and Ms. Curry indicated that they were checking for that.
Our investigator is currently in contact with the Highway Patrol. We are looking into this, Judge. We would not be opposed to an additional docket call for that reason.
All right, court will set Ms. Robinson for an additional docket call on March 7th at 9 a.m. And Ms. Robinson, once you sign and get the yellow copy, you're free to go.
That's all I have, Your Honor.
Thank you, Mr. Wright. You have anything this afternoon?
I don't believe so.
Have a good afternoon. Ms. Brumlow, are you ready?
Yes, sir. We have an agreement. Paperwork is here, so.
You go ahead and get Mr. Stucco. All right, this is cause number CR 22341, State of Texas versus Colby Taylor Stefka. Mr. Stefka, if you'll raise your right hand, I'll place you under oath. If you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you.
System class C.
Okay.
So there's minimal paperwork.
Okay. Thank you. All right, Mr. Stefka, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Ms. Brumbelow. Are you pleased with her representation of you? Do you feel, you guys say yes or no out loud so my court reporter can type it? Okay. And Mr. Stefka, do you believe that you've had enough time to talk with her about your case so that you have no further legal questions?
Yes, sir.
And everything that you have read and signed in this paperwork, you understand, is that correct? And where I see your signature here, you've only signed that once you have read it and you are confident that you understood what you were signing, is that correct? And that's your true and correct signature?
Yes, sir.
Ms. Brumbelow, do you believe Mr. Stefka to be competent to enter into this agreement today?
I do, Your Honor.
And it looks like Mr. Stefka was indicted with possession of a controlled substance in penalty group 2, less than 1 gram, a state jail felony. But the plea agreement today would be to a Class C misdemeanor offense of public order. Is that what it's called? Public order crimes?
Judge, our intention is it's attempted obstruction of a roadway. But that is a class C public order crime.
Okay. And Mr. Stefka, do you understand that the punishment for a Class C misdemeanor is fine only not to exceed $500? Do you understand that?
Yes, sir.
And the plea agreement in this case appears to be that you would plead guilty to a public order crime Class C misdemeanor, attempted obstruction of a highway. The punishment recommendation upon your plea of guilt is a fine of the amount of $320 plus restitution of $180, court cost of $76, and reimbursement fees of $20. Is that your understanding of the plea agreement?
Yes.
And that's what you're asking the court to approve today?
Yes.
And Ms. Brumbelow, that's your understanding of the plea agreement as well?
That's correct, Your Honor.
Okay. Mr. Stefka, then how do you plead to Class C misdemeanor attempted obstruction of a highway?
No contest. Judge, it's on. No objection, but no contest.
All right, and Mr. Stefka, do you understand that a no contest plea would have the same effect as a guilty plea legally if the court accepts your plea and later convicts you of the offense? Do you understand that? All right, then the court, based on the judicial confession of Mr. Stefka, hereby accepts his plea of no contest at this time. Court finds that Class C misdemeanor does not need evidence to support it. Court then, based on the judicial confession and plea, finds that there's sufficient evidence that Mr. Stefka be convicted of attempted obstruction of a highway, a Class C misdemeanor. Court convicts him on this date, orders him to pay a $320 fine, $76 in court cost, $20 in reimbursement fees, and $180 restitution. Is Mr. Stefka paying those today? You're gonna pay all that today? Okay. All right, Mr. Stefka, then the court's going to sign the judgment of conviction. Once you're fingerprinted, then Ms. Burns, will you, or Ms. Officer, will you make sure that he knows where to go to get these paid? All right, Mr. Stefka, come over here and be fingerprinted, and then we'll send you upstairs and you can make your payment. Is that all you have, Ms. Brumbelow?
That's all we have, Your Honor.
All right, if there's nothing further, you may be excused.
Thank you. I appreciate that. Right, Your Honor.
You too. Do we need Mr. Hawkins, anybody else ready, counsel? So you don't think yours is Boaz, right? I guess if she appears, do you want us to contact you?
Yeah, I'll be across.
To be across the office? Okay, we'll contact you.
I think she's.
Yes, thank you, Mr. Hawkins. All right, Mr. Miles, CR 22381. All right, Mr. Miles, I believe the last time you were here, we were set for arraignment and you indicated to the court that you were going to hire an attorney.
Yes, sir.
Can you give me an update on that, please?
I'm like $600 short. I'm going to check for some work I'm done. Previous, I should have enough to put down our retainers pay.
Okay. And which attorney have you spoken with?
Rollings, Wood and Pace, office.
Okay, and so have you already made any kind of down payment or partial retainer?
No, he wanted half of it, so I'm just $600 short. Minus of the check should cover having out today.
How much have you saved? How much do you have today to pay?
I have like 3,300.
Okay. All right, so Mr. Miles, if I reset you for. Or set you for 2 weeks, you think that you'd be able to pay your rest of your retainer today and be back? Okay,
Thank you.
all right, then. Do you have that, Deputy Everett?
Okay.
All right, thank you. All right, so I'm gonna reset you to February 21st. It'll be at 9 AM. It'll be in this courtroom
Thank you, Your Honor.
for arraignment and hire an attorney. All right, you're free to go. We'll see you back on February 21st.
Thank you.
All right, Mr. Copeland. Where's gonna be sent you? Just work your way over here. Mr. Copeland. I know it's tight quote. All right, this is a sanctions court hearing, CR 18360, State versus Bradley James Copeland. Let's see, Mr. Copeland, I've got the purpose for your sanctions court hearing. You had some community service and payments for a travel permit, I guess, that were issued to you in December. Says that you did not do your community service or make your payments. So why are we falling behind on our probation conditions?
Really no, I'm my payments are completely caught up now. I mean, wait, got joint custody of my 2 girls and 2-year-old son, and just work, a lot. Just trying to find time for the community service on weekends and chasing kiddos. And, like I said, they're really helpful. And I know what I'm supposed to do.
We're trying to keep you current so that you don't get to the end of your probation period and then have to get extended because you didn't find the time.
Yes, sir. I mean, I'm doing excellent with everything. I haven't record job in over 2 years.
That's good.
Yes, sir.
That's real good. All right, so this is what we're going to do. I'm going to give you, I need you to do 30 hours of community service before our next court date. Okay. And what we're going to do is so that there's got to be a carrot and a stick. Okay.
Yes, sir.
30 hours of community service or 3 days in jail. Okay. So the next time we come back, if you don't have 30 hours of community service, or don't bring them into court that day and say, here they are. Get them to your probation officer the Friday before your court date. Okay.
Absolutely.
So today is February 7th. I'm gonna give you a month. It's March 7th.
Is that extended on through my probation hour?
No, we're not adding hours to you.
Okay.
We're just making you do them. Okay, so March 7th. So you need to have 30 hours of community service done. And I understand what you're saying about kids and schedules and all that. You just have to figure out how to make that work because that's what you owe the state in your community service. Now,
And I work exactly half the month. I work on the drilling rig and I'm not here for 14 days. And I don't know if that helps me at all. And pretty much my time's cut in half. As far as being able to do it.
all I can tell you is work with your probation officer to see if there's something you can do while you work. If not, then you got half the month to get 30 hours done. That's 3 days. You can pick 3 days, do 3 10-hour days and be done. You work one first Monday weekend, you get 50 hours.
Yes.
One weekend. So if you're here 14 days and you're over the first Monday period, make arrangements for your kids, go knock out those 50 hours and you start getting ahead 20 hours at a time.
Yes.
And then you can, if all you're doing is community service, then as soon as you get that done, there's probably a good chance that you can get off probation early.
I wasn't, griping at all. I was just saying, I still have a week left at work. If you want this done in like 2 weeks,
No, I'm giving you 30 days. I'm giving you 30 days.
yes. Yes.
So just have 30 hours done, turn into probation the Friday before. So that means on Friday the 3rd, that needs to be turned in to your probation officer. And are you supervised out of here in Van Zandt County?
Yes.
All right, then they close at 12 on Friday. So get that turned in before that 12 o'clock period. And we won't have a problem on the 7th. If you come back and you don't have it done, let's say that you've only done 20. So what I'll do is I'll break it down. I'll say 3 days in jail, 30 hours. That's 10 hours for every day in jail. If you come back and you've only done 20, then you'll owe me a day in jail. Okay. All right. We'll see you back on the 7th. Is Rachel in there? Rachel? No, Rachel. I need Rachel or Carl. I didn't know if Carl has already talked to Mr. Mitchell or Mr. Jackson. He was gonna UA, so I'm just gonna go ahead and put them with him to get UA before I call their case, so. Mr. Mitchell and Mr. Jackson. Jaquavian Jackson in here. All right, go ahead and step outside and see Mr. Waddell. Both of you gentlemen are gonna step outside and see Mr. Waddell and be UA, and then I'm gonna call you back in, okay? Shannon, are you ready on anyone? And I've got other things I can do if you need time. I'm not rushing. You ready? Okay. Who do you want to go on first?
Oh, actually, I'm waiting on the commission's office process. We'll move on to Nash Fuller.
Nash Fuller?
He's in custody, man.
Yeah, let's see.
All right. Yeah, Henderson.
Kenneth Jerome Henderson, CR 22325. Have Mr. Henderson set for docket call today.
That's correct. No, quite ready. I was still negotiating the state. That's
Any objection?
Yeah, all right.
All right, court will set Mr. Henderson for an additional docket call on, are you available on March 7th?
This one.
All right, Mr. Henderson, once you sign and get the yellow copy, we'll have you back on March 7th, okay? Sydney Hiff, CR 22379. Mr. Hiff is set for pretrial.
That's correct, Judge. It's not what I have in the custody. That's on that. March 7th.
All right, court sets Mr. Hiff for docket call on March 7th at 9 a.m. and we'll be in this courtroom, Mr. Hiff. Anthony Wayne Murray, CR 22336. So Mr. Murray is set for pretrial today.
That's correct, Judge. At this point, I'm going to ask for the legal pretrial setting. I got some discovery last week, and I think it's delayed this office. But I talked to, this is the wood guy, we're requesting a pretrial.
Any objection from the state?
No objection, Your Honor.
All right, court will set Mr. Murray for an additional pretrial on March 7th at 9 a.m. And once you get your yellow copy, you're free to go, Mr. Murray. Michael Cole Tuff, CR 22296, the docket call.
That's correct, Judge. We received an offer from the state of being to accept that. We have to separately on.
All right, court will set Mr. Tuff for plea on March 7th. Will that be for time or probation?
Probation.
Probation. All right, so March 7th, 9 a.m. in this courtroom, Mr. Tuff.
Yes. Katie Williams.
Katie Williams, CR 22299. All right, Ms. Williams, set the docket call.
She is Judge. Received an offer from the state of the Ms. Williams that had a couple of appointments set up to meet for derailed by weather last week. We asked for an additional docket call, have that meeting, and hopefully come back with a resolution.
Any objection from the state?
There.
All right, court sets docket call March 7th at 9 AM. We'll be in this courtroom, Mr. Williams, or Ms. Williams. Ms. Williams, I have a note that says you're delinquent on your money. And more importantly, that you report poorly. That's the response I've gotten.
I just made a payment this morning, on my stuff to try to like listen to that, but, I was in there, I've never been told, report, just come to the courthouse.
Okay,
Come to my court dates.
well, that's what they're writing on my docket. So I want you to get with the probation officer, pretrial release officers before you leave and find out why that's being reported.
Yes, sir.
Nathan Capital. CR 22-220-221-231. So separate couple things. One, docket call in each case, and then I think there's an issue on pretrial release. Let's take the docket calls up first.
Okay, Judge, I was spoke with Mr. Woodward yesterday about Mr. Catfield. I think we're getting close to a resolution. I had some issues with my name yesterday, and I've asked the state to burn me a new copy. So from that perspective, we're gonna ask an additional about it. And I think we're almost there.
Judge, we have had extensive discussion regarding this. There's some questions about exactly what was said. There's going regarding the terrorist state threat of public servant. And that's really what Mr. Schmidt and I are negotiating at this time. And I want to make sure that he has the video. He can fully see what was said, and then we can, I have no doubt we will reach a resolution by the next docket call. So state will be unopposed.
Okay. All right, court will set Mr. Capville for an additional docket call on March 7th. 9 AM in his courtroom.
Mr. Schmidt. You requested you wanted to.
I didn't, she did that last time.
Okay, I just need to make sure I didn't need to tell her.
Now, the other issue when you take up is pretrial release. It's come to my attention that Mr. Capville perhaps has been arrested by Texas Parks and Wildlife for possessing a firearm, hunting without consent. New arrest, is that correct?
I can explain the situation.
No. Are you aware of this, Mr. Schmidt? Has it been brought to your attention? All right, state.
I was not aware.
I believe the probation department reported it to the state. Same time they reported it to me.
Yeah, I told on probation, that was before he actually charged me with it, came back like 2 months later and charged me with it, but I got lost looking for my dogs. And where I live,
That's okay. I'm more concerned with you being in possession of a firearm.
that's what I was explaining, I live on a deer camp.
I know, but you're not supposed to have a firearm. I don't care where you live. You're not supposed to have a gun while you're on felony probation and on my conditions of pretrial release. That's what I'm worried about. I got people accused of terroristic threat against peace officers, driving while intoxicated, possessing drugs in a correctional facility. And I've got you on release on bond, and one of those conditions is for you not to possess a firearm. And I've got you possessing a firearm.
I'm sure Your Honor, it was sent to my legal assistant who did copy me, but I didn't make the mention.
So what do I do? What do I do? I want to recall your case here in just a moment for the pretrial release issue. So have a seat in the hallway and we'll call you back in a moment. I'll give the state time to review that and speak with Mr. Schmidt, see if y'all can reach any kind of agreement on anything that perhaps would preempt me from having a pretrial release hearing. Mr. Schmidt, anyone else? Mr. Bustamante? CR 21-9, CR 21-281. What's the update on Mr. Bustamante?
Judge, at this time, we're gonna announce. I would ask the court to entertain in the future, despite its normal policy, that if we reach an agreement, that perhaps we bring that to the court's attention and do that prior to the jury trial, for jury selection. But we will have this ready.
Remind me, I think we were close to a plea at one time and there were some concerns about readiness. So to speak, and so I guess that has been taken off the table or.
Judge, I don't think so. I think a lot of it has to do with maybe my failings internally at our office that I hope to be able to rectify to Mr. Booth's satisfaction. But at this point, I haven't quite gotten there. I hope to, in the event that we don't, then rather than continue to drag out setting after setting. We put it on trial, and just move forward that way.
Okay. All right, court will place Mr. Bustamante on the jury selection docket. Let's begin that at the end of the month on Monday, February 27th. And the court will consider accepting a plea upon it being presented to the court. So, Mr. Bustamante, on the 27th, you're going to show up to the courthouse. This taper hand behind you will be out here in the hallway. Mr. Schmidt will not be required to be here, so you won't be checking in with him. We won't be having a hearing. You're going to show up. You're going to talk to Ms. Taperham. She's going to give you, you won't go to trial on that day. Okay, she's going to give you another date. We're going to continue to do that until your case reaches trial. Once your case gets closer to reaching trial, then Mr. Schmidt will appear with you and make an announcement to the court if we're going to go forward with a trial or plea agreement or something else. Okay, you understand that? All right, make sure you're staying in contact with Mr. Waddell. Okay, all right. Joseph Paul Cronin, CR 22322, docket call.
Judge, we're working the state still. That's very good.
Any objections from the state?
Where are we talking about?
Cronin, CR 22322. All right, there being no objection, the court will set Mr. Cronin for docket call on March 7th. Mr. Cronin, I show that you're delinquent on your pretrial release money, and my docket says that you didn't report in January. Did you report in January? Okay, this is what I want you to do then. At this time, you're not free to go. I want you to meet with Mr. Waddell and I want you to be drug tested. And then you already done that? All right, do we have the results on that? Don't know. So go ahead, you have a seat back here, and then once I get an update on that, then we'll finish your case up.
I talked to Ms. Margaret upstairs, and apparently Attorney Hester has contacted the court. Claiming he has COVID. I haven't had a chance to talk to him. I'll see if I can't get him some sort of confirmation. At this point, we're announced to the list of task force. Issue one, issue here directly. And then I'm going to get conditions for this Rollins and we'll do fairly.
Let's go ahead and announce Mr. Fuller, Nash Fuller, and we'll reset that. CR 2266, A versus Nash, Allen Fuller, set for arraignment, I guess still confirmed in federal custody in Seagoville. Do we know that?
I haven't, I know we had checked at one point and confirmed that. I have not checked the update card.
Okay.
Judging does still show to be in Seaville with projected release date of May 2023.
All right, so state's gonna continue its prosecution at this point. We know if we have a hold on him.
I don't know, Your Honor. I will say this is not one of the cases that the feds have contacted us, asking us to roll our case into theirs.
Patty, is Clay here? We asked him to step in. I'll show that he may still be on bond with Clay. He may want me to go off bond so we put a hold. Or maybe not. We'll ask and see. Good morning, Mr. Nicholas. Thank you, sir. Hey, Nash Allen Fuller, I show that he's on bond with Roy Brockway.
Yes, sir.
And our reports are that he's in federal custody in Seagoville. Do you know if there's any request to go off bond or a hold, or does he want to stay on bond?
Well, I've not had any discussion with family. He had a court date, I believe, last month, and I had talked with the states to figure out how we wanted to approach it, as if I needed to do a 17-16, or if they just wanted to issue the alias cases on the judge of nine side. Judge won't take 17-16 hold, kind of like TPC, so I don't know whether this option, or if I actually need to request it on.
Judge, I just took a look at the case. State will be tendering a motion to dismiss on the case. I believe that should take care of the vice problem.
Yes.
Okay, then on the statement of Ms. Heisel as an officer of the court will remove Mr. Fuller from the docket. And just ask that we can get that motion to dismiss today, that way,
State judge.
and the court will grant that motion once it's presented. Thank you, sir. Appreciate it.
I got a couple of warrants I need to do some felony warrants.
Okay.
Just ask you if you want to.
Negative. All right, well, Mr. Schmidt out there? I know he's probably working.
Here's the national.
Thank you.
I'm sorry, Mr. Schmidt, I know you're busy. I was gonna deal with Mr. Cronin real quick. Mr. Cronin, come on up. We're back on the record, CR 22-322. All right, Mr. Cronin, the pretrial release department has indicated, Mr. Cronin, come on up. The pretrial release department has indicated that Mr. Cronin was UA this morning and that he is negative. Are you able to make a payment today, Mr. Cronin, towards your pretrial release fees?
No, sir.
And why not?
I hadn't been working. I have a job.
How are you supporting yourself? Are you eating?
Yeah,
Are you drinking?
no, really.
I mean, not alcohol stuff, but I mean, you're taking care of yourself. So how are you doing that if you don't have a job?
My father took me out and then they give me some food.
All right, well, you're falling further and further behind. If Mr. Schmidt were able to work out a probation deal or something for you, I don't know that I'd be able to accept it because you're not even complying with pretrial release, you're not reporting, you're not paying. And so if you were trying to get your probation deal, it's probably not gonna work because you'd have to report and pay. And right now you're showing me that you're not reporting and paying. So don't say anything, don't say anything. So I've reset it to March. I expect there to be some kind of payment between now and March 7th, okay? It means get up, go get a job, make some money, support yourself, and take care of your responsibilities, okay? So see you back on March 7th.
Judge, Robert.
All right, we are back on the record, the cause number CR 22-220-221-221, State versus Nathan Allen Caphill. Mr. Caphill, I'm gonna set an additional hearing for you week after next on February 21st. And the hearing on February 21st will be for the court to determine whether or not it should revoke your bond for violation of pretrial relief conditions. And then we're gonna keep our March 7th date unless we come to an agreement on something that day, then the 21st will be the day I decide if there's evidence enough to revoke your bond. Okay. So we're gonna revise your notice of appearance, and then have you made any payments towards your pretrial release?
Yes, I paid him $80 today.
Okay. All right, we'll see you back in 2 weeks here in the courtroom. All right, Mr. Mitchell. This is Sanctions Court hearing. Caden Robert Mitchell, CR 21-403. All right, Mr. Mitchell, my notes say that you were positive for THC in July 8th of 22. That's quite some time ago. It says your levels are not decreasing. Means that you're continuously smoking marijuana. So I had you UA today, and you admitted to smoking on January 13th. Also show that you're on 3rd degree deferred probation for prohibited substance or item in a correctional facility, 3rd degree felony, 2 to 10. You got put on in May. You haven't worked any of your community service, 0 hours. And you're smoking weed. All that true?
No,
What's not true?
I don't continuously smoke weed. I was getting tested every time I come in.
Do you have a gum in your mouth?
Yes, sir.
Go find a trash can and spit that out. What is happening to our society? It just keeps getting worse and worse. It says it in the Bible. I mean, I don't know why we're surprised. All right, finish what you were saying.
This my probation officer told me that the levels were decreasing. She said that it might take some time to bleed off. Then I got sanctioned or whatever, because they weren't coming out. But
They're not decreasing because you're still smoking weed. You admitted that you smoked a couple weeks ago.
I said that because he asked me, just say the last time you would have been at the office, you would have been tested. So I told him the last time I was at probation. Wasn't admitting that I smoked that day. I wasn't trying to say that at all. He said, Mark, the last day you was at probation.
So when was the last day you smoked marijuana?
I couldn't tell you the last day. Because I don't smoke marijuana.
It says, I, Caden R. Mitchell, acknowledge that I have recently, on or about January 13th, consumed by smoking marijuana. And you signed it. Why would you sign that if you didn't smoke marijuana on January 13th?
Because clearly the test was negative, so you sign, I had to sign. If I don't sign it, then I don't understand that.
What do you mean the test was negative? You didn't take,
I mean, positive.
okay, about to say, because you didn't take the test, you just admitted.
I did take the test just upstairs. I just took it.
Will you get Mr. Waddell, because I'm thoroughly confused right now, and I didn't smoke weed. Why aren't you doing your community service?
I only get a weekend in. I'm out a whole month.
For what? For your job?
Yes,
What do you do?
I want to read.
Mr. Waddell, Mr. Mitchell says that he hasn't smoked marijuana and that you told him just to write down on here the date that he most recently checked into probation and that he's not smoking marijuana. Despite what this says, can you clear that up for me?
I asked Kate when the last time he used marijuana, and I showed him my phone, it's a day. And that was the day he gave me.
He said that you told him just to write down the last time that he was in your office or checking in for probation, and it was that date. But he could honestly tell me when he smoked marijuana. That's not what he told you?
That was not my line of questioning, sir.
So, Mr. Mitchell, what are we gonna do?
What are my options? I mean,
Let's see, first option is go to prison for up to 10 years. You want that one?
no,
Okay. Second option is do what you're supposed to do on probation or go to prison. You want that one? Do what you're supposed to do on probation or go to prison. That's option 2. You want that one? Guess what? I've already given you that one. You're already on option 2. You're supposed to be on probation, doing stuff to keep you out of prison, but you're not. You're not doing your community service and you're smoking weed.
I pay everything up to date. I keep up with everything. I'm in my class every time, every weekend with Chuck, whatever, I'm there. And I'm up to my neck in water just being here every weekend, pulling from the rig every Friday. Just to be up here Saturday and Sunday. I don't have the time for community service because I'm in class every weekend. From 6 to 9, from 12 to noon, or from 12 to 9, or 9 to 12 or whatever. So I'm working those doubles. I talked to Carl about it. If welding, I'm certified welder. I got excavators. I can go do whatever, they like whatever I can do to pick up 10 hours for community service. I'm putting it out there. I'm trying. Don't ever miss a meeting. I'm always at probation. I'm always there. I'm always pissing. I'm always like.
That's good because that's what you have to do. You act like you should get a medal because you're working hard and you're doing what you're supposed to be doing, except that you're not doing everything. What do you think would happen if I told my wife, you know what, I go to my kids' award ceremony at school and I go and I coach their baseball team and I go to their basketball team and I tuck them in and I love them, but you know what, I ain't got time to put food on the table. You think I'd be a good dad? Because I'm not doing everything I'm supposed to be doing. I'm supposed to be putting food on the table, right? But I do all these other things. I really ain't got time to go to work, make money. I do all these other things. You have responsibilities. And one of these is you got to do your community service. You can't say, I'm doing really well on these 6, but these 2 right here, the marijuana thing's hard for me and the probation's hard for me.
I still have another year for 200 hours. I bust that out. Like shit, an hour at first money, 50 hours. It's 4 weekends I work done. I'm done over.
Why would I believe that? You've done 0 since May of 22. You're going on 1. You're about to be at 1 year with 0 work, and you're like, hey, I can knock that out anytime I want. I know you're proving my point. 4 weekends, and you wouldn't even be here except for the marijuana. I would see right here that you should have had already done. I mean, May and you do 10. So let's say that you're at 9 months and you should have already done 90 hours. Should already done 90 hours. It says you're delinquent 80. Should have already done 90. That's my point. You're acting like, hey, it's not a big deal. I can get it done. Exactly. It's not a big deal. You should have gotten it done. I know I know it's good that it doesn't say that you're missing probation. It doesn't say that. That's good. But it does say that you smoking weed and you're not working your community service. I'm responsible for every one of those conditions. I can't say, we're going to do, 18 out of 20 this month and call it good. It's not how probation works. It's not. And you knew that when you signed up for it. You stood up here, you read the probation conditions, you said, I'll do that. I will do that. And now I'm telling you, you're not doing that. And I'm asking you, what are we gonna do about you not doing that? I wanna know.
What are we gonna do? Whatever we do.
What do you think I should do? What do you think the right thing is to do? You think I should just look the other way while you smoke weed and don't do your probation?
No.
Okay,
I'll do hair follicle, I'll do whatever else I need to do, come twice a week, or if it's twice a week, you can double up my hours, fine, I don't care what I do. I tell you this, I don't mind going to jail on weekends, whatever, but I have a class every weekend until March 3rd. So like I literally can't miss any of those classes or I don't pass it on.
and what class is that?
The second DWI, repeat offender
Repeat
DWI
offender.
class is. So I have that class plus my AA, or, the little meetings I have to do. Plus my actual counseling, which I have to pick up too, so.
All right, so you're gonna finish that up on March 3rd?
Yes, March
That
3rd,
weekend.
I get done with that, or I was looking on my phone right now, but I can tell you the March 3rd should be the last day, I think, for that.
Well, look on your phone. Let's figure that out.
March 3rd, Friday, to 9:30, my last day.
Last day for repeat offender.
We'll brief you with that.
Okay, and then, when did you say you do your counseling?
I still have to manage it through the weekend, like I still do it on the weekends too. Is it's really just because I can't cut it anytime like today. I was in some hot water for cutting out today, like my week time is very limited at all. I mean, I drill, so like without me there, it's a big hassle for everybody.
Okay, do you understand that the only reason you're here today is because what you've done?
Yes,
You understand that you're here today, not because I'm making you be here, because you're making me make you be here. Does that make sense? If you were doing your community service and we're smoking weed, you'd be on the rig right now. And you'd be reporting and doing probation, and I wouldn't be in your life. Your probation officer, y'all be handling all that. But when you're not doing what you're supposed to be doing, they have to come report it to me. It's their job. And so the reason you're here today is because of the decisions you made, all right? So I hear what you're saying, but the more you talk, the more it makes it sound like, man, what a huge inconvenience this is to you. And it is a huge inconvenience, but you're the one that put yourself here, okay? So I want to be clear about that. All right, this is what we're gonna do. I'm gonna sanction you for the marijuana and for the community service. I'm gonna sanction you to 3 days in jail. I'm gonna let you do that on the weekend. We're gonna put that after your repeat offender class. I'm gonna have you come back on Tuesday, March 28th. And I want you to do your 3 days in jail on I'll let you pick the weekend. You want to do it? Look at your phone. Look at your phone. Look at your calendar. What does your shift look like? Are you week on, week off, 2 week? What do you do?
oh, no, I'm month straight, I don't come back. The only reason I come back is for this, you said March, you want me back March 28th? Record?
I want you back March 28th to court. So tell me, when do you want to do? I need you to go in on a Friday night at 8. I'm gonna let you out on Sunday at 8.
At 8 or not?
8 p.
Okay, yeah. Just, I mean, what, court that 28th, do you want? I can
10th,
just do-
17th to 24th.
I can just do the 31st, I mean, the rest of that, that weekend.
No, I want you to do it before you come to jail, because that way, if you come back, I want you to do your jail time before you come back to court.
Oh, do it before?
Yeah, so look at the weekend of the 10th, 17th, and 24th.
Oh, let's just do we do the 24th and then back it out and be here 28th. That way I'll just take all 4 of those days and say I was. Of course.
You want me to have you go through the 27th? You wanna go in on Saturday, do Saturday, Sunday, Monday?
Yeah, that would be,
All right, let's
that'd be great too.
All right, let's do that. So we'll say 3:25, we'll go in. That's a Saturday, we'll go in at. Let's go in at 8 AM on that Saturday. And then we'll let you out on Monday at 8 AM. And then you can come see me the next day. And so, and I want at least 10 hours of community service, at least 10. I know it's gonna be tough, but I'm not saying 20, I'm not saying 30, at least 10. Okay? All right. So do you have a notice of appearance? And Rachel, can you get me an order of commitment for those dates, March 25th, 8 AM to March 27th, 8 AM? So that I can get him a copy of that. And when you show up, you gotta have your ID.
No, I've never done it, which is not here, I've done it with Smith, but I've never done it here.
Yeah, so you'll take this order of commitment, and you'll take a photo ID.
So I'll just go to the.
Yeah, you just take that out to the jail up there and they'll book you in and book you out. So she's gonna get the paperwork done up. I'm gonna give you this notice of appearance. Yeah. I've already been up there. All right, Kate, I'm gonna have you sign right here. I wrote on there 10 hours of community service, what your jail commitment is. They're gonna have a specific order you'll need. So once you get this, have a seat in the hallway until Officer Insurer comes and gives you that order of commitment. I'll have to sign it. You'll have to take that with you to the jail. Okay? Sign right there. We're gonna give you a copy. Okay. See ya. What was that? Right. Yeah, go ahead and have a seat. Carl, I think Rachel's working on an order of commitment. All right, Mr. Smith, who are you ready now?
Commissioner Williams and. Richard Jordan Williams, because lab didn't get printed. Oh, can we announce on Commissioner Williams?
Tanisha Williams, yeah. All right, Tanisha Williams, CR 22-199, withdrawal.
Judge, we don't have any best figure at this point in time. I believe that we reached the agreement with the state. That's to be separate. March 7th.
All right, will that be for time of probation?
Probation.
All right, court sets Ms. Williams for plea on March 7th at 9 AM in this courtroom. Yes, checking with Mr. Waddell. I show that you're delinquent on some of your money, so
Yeah, I think I over. Last minute this month.
Can you make a payment today?
Yes, I heard.
Okay, see Mr. Waddell. All right, this is cause number CR 22-226, State versus Jennifer Danielle Rollins. Ms. Rollins, if you'll raise your right hand, I'll place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, thank you. Lower your hand. Speak up loudly and clearly, and just make sure you say yes and no to answer so my court reporter can take it down. Your name is Jennifer Danielle Rollins.
Yes,
And Ms. Rollins, are you a United States citizen who reads, writes, and speaks English?
yes,
And Ms. Rollins, have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney? Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered? Is there anything about the paperwork that you've read and signed today along with Mr. Schmidt that you do not understand? Mr. Schmidt, do you believe Ms. Rollins to be competent to enter into this plea agreement? And have you explained to her her rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea? All right, Ms. Rollins, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. A first-degree felony in the state of Texas, if convicted and sentenced, carries a range of punishment of not less than 5 years in prison or more than 99 years or life in prison, and a fine not to exceed $10,000. The plea agreement appears to be that you would plead guilty to that crime. The state in response would recommend a sentence be deferred, a finding of guilt be deferred. That means that the court consider the evidence but not convict you this date, defer a finding of your guilt and place you on community supervision for 8 years, order you to pay fines, court costs, restitution, reimbursement fees, and the state would be dismissing several cases. And you've read over this plea agreement and you understand what the plea agreement is. Is that correct? Do you understand, Ms. Rollins, that if I approve your plea agreement today and place you on deferred community supervision, that if during your period of probation, community supervision, if you violate any of the terms and conditions that you've read over and signed today, that the state could file a motion to adjudicate your guilt, that means to convict you, could set you for hearing with the court, and they could put on evidence. And if they prove to me that you violate any of your conditions of community supervision, the court could do several things, including revoke your community supervision, convict you of the offense, and assess a prison sentence to you anywhere between the minimum 5 years all the way up to the maximum 99 years or life in prison. Do you understand that? That is a tremendous range of punishment for a crime like this. You understand that? And you've weighed that. You've weighed the pros and the cons and the risks involved with doing that. And you've talked with your attorney about that. Understanding the plea agreement, understanding the range of punishment, understanding what consequences would be if you violated your probation. Do you still wish to go forward? All right. So Ms. Rollins, then how do you plead to manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence? All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial profession. Anything further from the state?
No, read the rest of
From the defense? Court's going to review the evidence briefly. All right, the court has reviewed the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement reached between the state and the defense. Court hereby defers a finding of guilt places Ms. Rollins on 8 years community supervision, orders her to pay a $2,500 fine, $180 restitution, $290 court cost, and $535 in reimbursement fees, and the court will dismiss under section 1245 all cases referenced in the order of deferred adjudication and as referenced in the plea agreement. All right, Ms. Rollins, you're hereby remanded to the custody of the Van County Community Supervision and Corrections Department, so they can carry out the terms and conditions of this sentence. I'm going to have you come forward at this time to be fingerprinted with Deputy Everett, and then the probation officers will give you more information.
Before we bring it over.
We were set for competency evaluation status today, is that right? Court calls cause number CR 2267, State versus Robert Gerard. I've got docket call and the competency evaluation today, Mr. Schmidt.
Judge previously, at Mr. Gerard's request, I thought motion to withdraw in court. Evaded the motion pending the outcome of the competency evaluation that's been confirmed. And reiterates my motion to withdraw at this time. That is what.
Yeah, Mr. Gerard request. Mr. Gerard, are we still having a concern?
Yes, I'm getting an attorney out of the office and I'm in correspondence with him right now.
Okay, who are you hiring?
I have a couple I'm talking to.
Have you,
When they come, I'll sign them to the docket.
okay,
They'll sign them to the docket.
but can you tell me who it is that you've spoken to? Like,
No, sir.
do you not know their names or?
I can't remember them, I really can't.
All
All right,
right,
so last time, I didn't even get to come into court. Y'all didn't even let me come into the courtroom. And then y'all sent back to my cell to come to court today after I bonded out. Last time I walked in the court with him, we were supposed to be talking to a specialist. And then I walk in, we're doing a docket call instead of talking to a specialist. And I don't know, are we at a docket call right now? What are we doing today?
we were at a couple things. We were at a docket call and then a status on the report for the doctor that you met with.
Right, well, he's a head shrink. I don't need a head shrink.
I understand.
I'm not crazy.
I know, but that's,
I know you need it for court.
I do need it for court. That's
I need
exactly
a
right.
specialist to evaluate the surveillance, and they lost the phone that was supposed to be introduced into the case.
I know, and
So
Mr. Smith,
it's like a little sloppier than I wanted to do, so I want you to get in and reorganize everything.
okay. And Mr. Smith has brought all that up to the court. And yes, I'd ordered the psychiatrist to interview you to give me a report, and that report has come back. The problem that I'm hearing though is that you and Mr. Schmidt can't, y'all don't have that attorney-client relationship anymore that's healthy to the point where you can communicate to Mr. Schmidt, where he can communicate to you, and that y'all can get on the same page with how to defend your case. So that's what I'm hearing is the concern for you. And Mr. Schmidt, as an attorney and officer of the court, has brought it to my attention that you don't want him anymore. And so he's asking the court to allow him to withdraw as your attorney. And my only question is once I allow Mr. Schmidt to withdraw, then you don't have an attorney. And that concerns me because now you're by yourself and we're supposed to be moving forward with your case and you won't have an attorney representing you. That's why I'm asking, who is it that you're talking to so that I know that you're being represented?
Do you want me to look on my phone?
Do you on your phone, do you have
My
it?
phone's outside.
No, that's okay. That's okay. So you're telling me that if I allow Mr. Schmidt to withdraw, that you're going to hire an attorney?
Yes, sir.
Okay. All right, Mr. Schmidt, then I will reconsider at this time your motion to withdraw as counsel, and the court will grant your motion to withdraw, and you are removed from Mr. Gerard's case at his request.
Thank you.
And I'm doing that, and I'm not appointing counsel for Mr. Gerard at this time. He's been found to be indigent at this time. However, at his request to hire an attorney, I'm not going to appoint you an attorney at this time. I'm instead going to reset your case and give you time to hire your attorney. All right. So we're going to reset the docket call to March 7th. So that's 30 days.
30 days.
That's 30 days. Okay.
And on the reset, we're coming back for a docket call.
We're coming back for a docket call and competency evaluation, all of that.
Okay.
The status on that.
Okay.
But everything that we were set for today, we'll discuss again on the 7th.
All right.
All right. Now, there's one other, Mr. Schmidt, that's all. You're excused. The only other issue I have, Mr. Gerard, is that I asked pre-trial release. I asked Mr. Waddell to get a UA sample from you
You
today.
got a UA from me, all right.
And he told me that it's not sufficient. So I'm going to need you.
No, I just went up there and passed the UA.
I understand. He's reported.
So
Listen,
I bonded out a $10,000 bond.
I understand.
I have my own pre-trial or a PR bond. I don't get that.
You're not on PR bond. You posted a surety bond. And part of your conditions of being on a surety bond is that you're going to be subjected to your analysis exams anytime that I say.
And I just took your analysis exam and passed it.
I understand. He says that it's insufficient.
I don't know how to say sufficient. I just went up there and took
It
your
does,
analysis and passed it.
it doesn't matter what you think. It
Matter of
matters.
fact, I have an EEG board on my head and I'm gonna send you the video of me passing that UA.
Okay, that's fine. But I'm going to want you to give another one. Okay. If you pass the first
Okay.
one, you'll pass the second one. Okay.
I will send my lawyer up here to see you because I did pass that UA.
Well, your lawyer's supposed to
I
be
took
coming to
that.
see me anyway, because
Yes,
that's part of the
we
deal.
have lawsuits against you because my estate is ruined from y'all locking me up for 8 months.
That's
I'm
fine.
leaving my doors unlocked, 26 unlocked doors at my estate, and my roof is falling in, and they stole all my cars, stole all my titles, stole all my fucking jewelry out of it. Excuse me, sir. Excuse me.
Y'all have lawsuits coming from us. Y'all have ruined our state. Your electronic monitoring system has been on for 10 years. 10 years. I can catch it with my EEG board and my security system. I'm a federal testing site. It says Van Zandt County Sheriff's Department and annex buildings signals on my head for 10 years straight. It's annoying. It's a mess. And it's injustice. And I'm suing everybody.
That's fine.
I'm suing from the top down. So you can do all your little authority and all that stuff. Get that electronic monitoring system off my head. Quit talking into my skull with that B2K, whatever y'all call it. Got me?
Yes, sir.
Yes, sir.
Clear.
Yes, sir. Thank you. That's what the auditory hallucinations and the little expert stuff is amounting to. I'm not crazy. I have that.
Understand.
I have that surveillance.
Understand. And no one's saying that you're crazy.
Yes.
No one's saying
Thank
that.
you.
I'm just saying that I
I'm gonna
need,
send you the video,
okay,
but I'm really gonna show you in court when I see you.
that's fine.
Get it off my head, please.
I will.
Thank you, sir.
That's fine. But listen, I need you to take the other test. And so,
I need you to get the electronic monitoring system from Van Zandt County Sheriff's Department annex building off my head.
okay, but you gotta,
Can you
give-
tell them?
you gotta go give, are you gonna give me a test,
You need to get that warrant and get it off my head.
Mr.
You
George?
need to get the warrant for the electronic monitoring system, get it off my head.
Mr. George, listen,
Yes, sir.
are you gonna give me another test?
Yes, sir. I will give you another test. Thank you.
Okay,
Do I have anything to sign?
no, not right now.
Okay.
Step out.
Electronic monitoring, so we have tasks. Electronic monitoring is in the Van Zandt County Sheriff's Department annex building, all property garage state.
Yes, sir. Go
Thank you,
out-
sir.
Go outside and see Mr. Waddell.
Thank you.
Give me that test and then come back in and have a seat, okay?
What do you mean I need that?
Because I haven't done your resetting, we haven't done your date. I gotta give you all that to sign.
67 years old, she's been sitting here for 10 hours.
I don't think she's missing.
Mr. Waddell, can you bring Mr. Waddell and tell me why it's insufficient? Can you tell me why it's insufficient? Because I peed and he said it was good.
Understand? I'm telling you, I want you to give another one because I believe it to be insufficient, okay?
Okay, listen, Mr. Waddell, it's insufficient on my test. Because you said it was a good specimen.
I don't believe you.
You don't believe it was my urine, I peed right in front of us. I peed right in front of you. You handed me the cup, you took your cup out, I peed right in front of you.
I couldn't see.
No, you were standing right here, listen, no, see that is.
Listen, and
You were
listen,
standing right beside
Mr.
me.
Gerard, listen, Mr. Waddell, Mr. Gerard,
I feel like you're
I
trying
need,
to lock me up.
listen,
Are you trying to lock me up?
not trying to lock you up. I want you to give another
You
seat.
should consider my surveillance because you have that electronic monitoring system from his office for 10 years straight. Van Zandt County Sheriff's Department, is that right beside the adult probation office?
All
Is
right,
that the building right beside the adult probation office? Yes. All right, so that signal's been on my head for 10 years. Get it off my head. Thank you.
all right. So Mr. Gerard, go with Mr.
So
Waddell.
that's that. You get your warrants right if you're gonna stalk me around the world and ruin my house.
Mr. Gerard, I want you to go give him another urine sample, okay?
Come on. Come on.
Chad. Chad,
No, I'm not leaving my focus.
Motion God.
okay, let's get Chad. All right, go ahead, Ms. Heisel.
Your Honor, are we on record?
Yes.
Your Honor, the state would make an oral motion to amend Mr. Gerard's, pre-trial release to include no contact. Originally, the commission said no contact with the victim, however, the victim in this case, we are requesting no contact with the victim's mother and sister. I provided their names to you by email for spelling purposes, but it's Christy Molhart and Linda Love. They contacted our office and requested that. We don't want it to be anything that would hurt them. They're all related to them, but Gerard contacting his own family, but the victim's mother and sister would like their protection.
All right, the court will review the conditions of pretrial release. If there are not conditions already prohibiting contact from Mr. Gerard to the family members of the alleged victim in this case, specifically the mother and the sister of the alleged victim, then the court will grant the state's request. The court is considering this request. I want the record to reflect that Mr. Gerard is not in here. He has been asked to provide the court with another urinalysis sample. I consider this the pretrial release conditions of the court. Court does not believe that this is adversarial point in the proceedings that Mr. Gerard needs to be in here. So the court's going to consider that request. And the court will grant that as safety to the community and to the alleged victim's family.
Thank you, Your Honor.
And so you said you provided that to, you said you emailed it.
It to you and call Mr. Schmidt on it. Mr. Schmidt was attorney of record at that point for spelling purposes.
All right, court's going to recess.
Reason the first test?
Listen, I don't want, listen,
I wanna go on record. Are we missing the first?
we're on record, listen, we're on record. No,
Alright, so
no, stay right there.
on the first test, where's the first test? The urine sample.
The first,
That, I wanna see the first test.
the first test has been deemed invalid by this court, and I'm
I wanna
asking,
see it
listen,
invalid, brother.
you're
I
not,
didn't get to see it.
you're not
I
gonna,
didn't get to see it, and I didn't sign for it.
I'm not using that against you.
Because he told me before I walked out the door, it was good.
Here's the bottom line. I don't want you to address them anymore.
All right, so what do you-
Listen, listen, what we're doing with your statements is, this is
All
what,
right, so
this,
back to jail.
you're about to go back to jail right now if you don't calm down and let me talk to you.
Yes, sir.
Okay, no more talking.
Because I
Listen, no more talking.
smoked the joint.
No more talking.
I'm about to smoke. I smoked the joint. I'm about to piss in that cup and it's going to say I smoked the joint and I smoked a joint. Who gives a fuck what I smoke? If that
I
bitch-
care, I
All
care.
right, so how many years test do I get? Do I get 1 or 2?
You get 0.
0? Let's go to fucking jail, because I want to see the other cup that was good. That was good. I'm not about to piss again, and you got a hot cup or whatever. Hang on a second. Where's the first test? I want to see the first, I don't care. If you just trying to lock me up, we're gonna try to lock me up. I want to see the first test. I'm gonna give you a second here. Where's the first one? Something about the good. No, where's the first? Where's the first? Look at me. What's the first year in 7? Is it supposed to keep it if it was bad and send it to the lab? Aren't you supposed to send that to the lab? That's wrong. Yes, you're supposed to send that to the lab.
Listen,
So I give you another one. Let's go to the 10.
All right.
Thank you.
All right, so
Let's
listen.
do the 10.
all right, let the record reflect that Mr. Gerard is refusing to give the court another urinalysis upon being ordered.
It's a good dollar. I got a real dollars.
The court's going to find him to be in violation of this condition of provisional release for failure to provide a urinalysis. The court's going to order him in custody at this time.
So what's my bond? If you don't mind me asking.
I'll determine that once you're in custody.
Can I have a bond?
When you get to the jail, I'll have a bond.
It's bullshit. You got lock me up. I ain't got a lawyer, man. I ain't got a lawyer.
I know
I don't care if I got it.
Yeah.
You need your lawyer.
you're going to talk to your mom.
Here, Jane, look, dog, you trust them. Let me go. Let's do it. What about it?
We'll send over the notice of appearance and I'll send an order of commitment. All right, this is cause number CR 21361 State versus Duquavian and Jackson. This is a sanctions court hearing. Let's see, Mr. Jackson. I've got some notes in my docket here that say a couple things. I'm gonna read it to you, okay? It says defendant does not seem to be motivated since he was placed on probation. He was a no-show as requested on the Smith County UA line on January 3rd of this year. Defendant has not worked any community service hours or taken his drug offender education class. According to Smith County Community Supervision, defendant misses most of his appointments and has to be rescheduled each month. Mr. Waddell, you tested Mr. Jackson today, correct?
Yes, Your Honor.
And it looks like he admitted that he smoked marijuana on January 16th.
That's what we told me.
All right, so. All right, Mr. Jackson, so tell me. The things that I read, are those things true or not true?
It's true.
True. Why are those things true?
Lack
And
of
listen,
transportation.
and listen, I want you to listen, I want you to just be, I'm always gonna be 100% honest with you. And so you just be 100% honest with me. Okay? So why are those things true?
Community service hours, lack of lack of transportation, the smoking part. I just smoke to go to sleep and then. It's all true.
And what?
It's all true.
I know, I mean, why is it true though? Why are you not doing your community service?
Lack of transportation, my parents and myself have working.
Do you have any friends
No,
that you can call to get you somewhere? Is there a bus that you can take? Can you walk? You look like you're a well-bodied young man. Can you walk?
yes, I want to report and take my UAs.
Why don't you walk to your probation?
Because
I mean, to your community service?
it's 4 hours, not 4 hours, it's 4 miles away.
Well, what's worse, walking 4 miles or going to jail or going to prison? You understand that you are on probation for, and you should understand this because you signed and you read everything and you told me that you understood the consequences, that you're facing up to a maximum 2 years in a prison where there is no parole. You understand that? Okay. You've been on since April of 2022. And you haven't worked, you got 350 hours of community service that you have to work. You've worked 0. And next month or 2 months from now, you'll be on for a year. So you walking 4 miles is probably worth, to me, it would be worth doing that. So I didn't have to get in trouble with the judge and possibly go to prison. Wouldn't you agree?
Yes,
Do you feel like you're doing everything that you can?
no, sir.
Do you feel like you can do more?
Yes, sir.
You understand that if you don't do more, that ultimately you're gonna end up back in this court on a motion to revoke. And you'll be looking at either being placed on a 10-year probation and be a convicted felon, which would affect your ability. Are you a convicted felon right now?
No, sir.
Okay, is this the only probation you have?
Yes, sir.
Okay, so how old are you?
19.
Oh, man, 19 years old. I mean, I knew you looked young, but I know you were that young, 19. 19 and you're already on papers facing prison. And you're already before a judge who's put you on probation, who's lecturing you about why aren't you doing what you're supposed to be doing on probation. You don't want to be a 19-year-old in prison. You don't. You don't. You would not survive in there. I mean, I want you to have this needs to be a wake up. Is this your mom?
Yes, sir.
You think she wants you to go to prison?
No, sir.
Do you think that she'd be worried about you every day that you sat in prison?
Yes, sir.
So what are we gonna do?
My community service hours. And stop smoking marijuana.
Do you have a job?
No, sir, that's what I've been looking for.
You're gonna have to get a job. There's a lot of people out there hiring people.
Yes, sir.
It may be harder for you because you're on probation now for a felony. But I promise you this, what do you go by? Do you go by Jaquavian? What do you go by?
Quite.
Quay? So Clay, do you understand that if you end up being a convicted felon, that that's going to affect the rest of your life? When you go to get a job, when you go to buy a car, when you go to buy a house, you do anything where somebody's checking your background and they see that, it's going to keep you from getting a good job. You're going to pay more for cars. You're going to pay more for houses. That's what a felony conviction will do. It will shape the rest of your life for the worse. It'll make your life harder. Other people will get ahead of you because you have a conviction and they don't. Even if you were smarter and better at the job, they're going to get it over you, because when they flip their paper and they don't see a conviction, and they flip your paper and they do, they're going to pick that other person. I mean, it's something serious. And as a 19-year-old, I wouldn't have known these things. But sitting here today as a 45-year-old who has a 21-year-old son, I have told him the exact same things. I've got more life experience than you do. And I want you to wake up. And I bet your mother has probably told you these things, hasn't she? Has your mother lectured you? Has your mother told you about doing right and doing what you're supposed to be doing?
Yes, sir.
You know why she's doing that? Why is she doing that?
Cause she knows.
Huh?
Cause she knows.
Because she knows, and why else? Is she because she wants to be a mean mother? Because she wants to discipline you all the time? Because she wants to keep her thumb on you because she's mean? Wow. Why she? None of those things are true. Why do you think she's doing it?
So better myself.
But why? Why does she want you to better yourself, Quay? It's easy. 4-letter word.
Cause she loves me.
Ah, there you go. She loves you. And she wants you to better yourself. And she doesn't want her baby in prison. And she doesn't have to worry about it for 2 years, day for day, no parole. So you need to be thinking about these things when you want to hit a joint to go to sleep. They're not going to let you hit a joint when you're sleeping in prison. They're not. You'd be begging to do probation than having to watch your back every time you turn around in prison. You'd be begging to do probation. You'd be begging to walk 4 miles to a dog shelter to wash a dog or whatever you need to do for your community. You'd be begging to do that. You'd be begging to eat your mama's food. You'd be begging to hang out with your friends. You'd be begging to flip a burger at Burger King or whoever would hire you right now. You'd be begging to do that versus sitting in prison for 2 years, watching your back every time you turn around, sleeping with both eyes open. You hear what I'm telling you?
Yes, sir.
The reason you're here today is because the probation department has said this kid is starting to go astray. And we need to get his attention. Because if we don't, it's going to be too late and he's going to go to prison. That's why you're here today. They could have easily just filed a motion to revoke. I could have come in, the DA's office could have proven to me you didn't do any community service, you're smoking weed, you're not doing your classes, you're not taking it serious. And I could have said, oh, just another statistic, stamp it, Quay's gone, next. We could have done that. But they didn't do that because they want you to be on probation. They want you to be successful. They want you to get off probation and get the government out of your life and let you go and be changed and be different. That's what they want. Okay,
Yes,
so that's got to be your perspective. Nobody's trying to pick on you. Nobody's trying to hold you down. People, everyone that's involved with you right now is trying to get you to the next place that's good and not bad. All right. So listen, there's going to be a consequence for your decision. All right. So I'm gonna sanction you. I'm gonna give you 3 days in jail for not showing up for your UA on January 3rd. You're gonna do 3 days in jail. Okay?
yes, sir.
I'm gonna set you another date. We're gonna come back on March 28th. Okay? Between now and then, I'm gonna let you do 3 days in jail. I'm gonna let you pick those 3 days. You can do them on the weekend. You start today, you do whatever you want. I'll let you give a probation. You'll tell them the 3 days, and then you'll have to come down here to this jail. And you'll have to sit in that jail for 3 days.
Yes, sir.
All right. And then before you come back, you need to have some money paid. You need to have $85 paid to your probation. You need to have $130 paid towards your court costs and fines. Okay. It means if you ain't got a job, you better go find a job.
Yes, sir.
This ain't your mother's responsibility. It ain't her job to pay your stuff. If she'll give you a job, then you better take it. But it's not her job to come in here and pay. It's your job. You're on probation, not her, okay? And I need 15 hours of community service. If you ain't got a job, there's no reason you can't be knocking out your community service. And you need to enroll in your drug offender class. Just enroll in it. Those are gonna be the things that you have to do before you come back on the 28th. And you need to do all those things to have all that done before the Friday before the 28th. So on March 24th, all those things need to be done and turned in your probation department. So when you walk in here on the 28th, the probation department gives me a sheet like this right here. It's got your name on it. It's got all the stuff that you did do or you didn't do. And I want to see complied. That means he did it. He did what he was supposed to do. Because if it says it doesn't comply, then either that jail time is going to get a lot bigger, or I'm just going to tell him, file your motion to revoke. Okay? Any questions about that? All right. This is a reality check wake-up call for you. All right? So walk out of here today and know that you have a chance. You're given another opportunity. Officer Mature, can you get these written down for Quay so he'll know what he's supposed to pay, or give him a copy of this? I don't care. That way he'll know what he has to do.
I wrote about this.
Oh, you did? Awesome, thank you. And then see Officer Mature, see Officer Mature. You're gonna give her the dates for your jail. And listen, hey, when you go, you need to show up with this. There's gonna be an order that I'm gonna sign that's gonna have the days. When you go, you need to take that along with your photo ID. So without your photo ID, they're not gonna let you in. And they're gonna call me. They're gonna say he didn't bring his photo ID, so he didn't do his jail time. All right. Mom.
I asked Miss Patty about it. She said she'd give them, if you have it.
This is Alvarez. This one's fairly relief. Run this one right here.
Thank you. How are you this morning?
I'm doing fine. It's been a Hectic morning, to say the least. All right, Mr. Everson, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. You are Jesse Henry Everson, is that correct?
Yes, sir.
And Mr. Everson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Zach Elliott. Are you pleased with him as your attorney? You feel like you've had enough time to talk with him about your case and had all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
And Mr. Elliott, have you explained to Mr. Everson his rights as they pertain to this case?
Yes, your honor.
Have you also explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, your honor.
And do you believe that he understands his rights and the deferred adjudication?
Yes, your honor.
All right, Mr. Everson, it looks like you were charged with a second-degree felony offense of arson. A second-degree felony in the state of Texas carries a range of punishment if convicted and sentenced to not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $20,000. I see the plea agreement in the case is that you would plead guilty to arson today. The state would recommend that the court consider the evidence but defer a finding of guilt. That means not convict you of the offense, but place you on 10 years community supervision. And the court would be dismissing and taking into consideration the other arson charge in CR 2296 and DA 2022-0202 interference with public duties. You understand, Mr. Everson, if I approve that plea agreement and place you on community supervision, if during the next 10 years you violate any of the community supervision conditions that you've read over and signed today, do we have those? If you violate any of these, you understand that the state can file a motion to adjudicate your guilt, that means convict you. And they could put on evidence, and if that evidence proves to me that you violated any one of these, the court could do a number of things, including convict you of the offense, revoke you from community supervision, and place you into prison anywhere between the minimum 2 all the way to the maximum of 20. Understanding the risk inherent in that, understanding the consequences for violations, understanding the range of punishment, do you still wish to go forward? All right, the court would then ask you, Mr. Everson, how do you plead to the second-degree felony offense of arson? Okay, you say guilty, and you kind of had.
Yes, yes, sir.
Is there any question about whether you're guilty of that offense?
No, sir.
And I understand it may be a significant decision and maybe a hard thing to say and a hard thing to do, but are you telling me that you are guilty because you believe and know that you are in fact guilty of committing that offense?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty today?
Yes.
All right, the court will accept the defendant's plea of guilt. Mr. Elliott, any objection to the state's evidence? All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, we are in, state is in victim compliance. We will find that have been referred to a victim in this charges, victim impact statement. We would ask that you evaluate that before pronouncing sentence.
All right, thank you. All right, the court's going to review the victim impact statement. All right, the court has reviewed the victim impact statement. Mr. Woodward, is there anything further from the victim as to whether she supports this plea or doesn't support this plea?
Judge, my victim impact coordinator, my victims assistance coordinator has had numerous conversations with the victim in this charge. Obviously, she is very, very distraught about this. Given Mr. Person's history, we believe that this is in the best interest of justice. I don't know specifically whether she is unsupportive. I think that for her, this is very personal, and she would like full prosecution. Given the objective realities of this, we believe that this is in the best interest of both the community and Mr. Everson.
I'm gonna admit, this is kind of tough to stomach, and there's two charges of arson. Is my understanding that there's two houses that burned?
There were two houses in that district.
And is the other house also a family member?
No, Your Honor. I believe both houses were. I'm gonna say quote unquote abandoned. I believe this victim's house was under renovations, is my understanding. The other house was abandoned. There is an owner that has not complied with. We attempted to notify, but have received no communication back from the other victim.
Court has reviewed the evidence. Find the evidence sufficient to convict Mr. Epperson, but the court is not going to accept the plea agreement at this time. So I will allow Mr. Epperson to withdraw his plea of guilty. And so we can let's reset this, or I can recall it later today.
Judge, if we could reset it a short period so we can, Mr. Elliott and I can discuss further.
All right, court will reset Mr. Everson for docket call on March 7th at 9 a.m.
Would you,
Are you available? Yeah, check your calendar. Are you available on that day?
would you have a moment to have a mediation that starts at 9? I'm not sure if it's gonna be in Greenville.
We're about March 9th. Would that be better?
Yes, sir, I'm available. March 9. Go off the record for a second.
In just a moment, but I've got another plea with a victim allocution. If you want to remain, then I can meet with counsel after. But I've got another plea with a big victim allocution.
And Judge, my request for the reset was so we could maybe meet chambers and discuss certain issues, and then we can reconvene on that next day and hopefully have a resolution, or we can set for trial, whatever we need to do.
Yeah, I mean, y'all can either wait and we can do that over the lunch break, or we can do that between now and.
Right, I knew we had more things on the docket today, so I didn't think we were gonna have time right now, so.
So yeah, we can
But
do
once you
it.
give us time, so we could find the time to do that. I didn't know what Mr. Elliott's schedule was, so I wanted to give him time.
Yeah, we can do that.
Thank you, Judge.
Docket call March 9th, 9 a.m. We'll be in this courtroom.
Here to start. My spirit starting to
Yes.
Look at the Sanctions court dockets. Yes,
So,
Finland didn't show up.
so I think we did this.
Yes.
And we did that. And I think we said, 3, maybe. Do you need the other one? Scott.
No, sure. Thank you.
Y'all need it to the number.
What? I got it.
Want to just figure out a time.
And I don't care if they sit there or they stay, I don't care what they stay. What the
We're
big,
gonna have him sit here.
said, yes, I'm going up.
Like we said, that's a lot of good things. Who's gonna go down? We're gonna do 5.
I do need this order, these violations. All right, we're going on the record. This is cause number CR 21-384, CR 22-136, 137. Turn your cell phones off. Everybody get your cell phones out and turn them off right now. Not silent, not mute, turn them off. Cause number CR 22-137, 138, 139, 140, 141, 142, 143, 144, and 145. State of Texas versus Jeffrey Lance Gurley. Mr. Gurley, from where you're sitting, if you'll just raise your right hand. You can stay sitting. Raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you don't. All right, you can lower your hand. Mr. Gurley, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Richard Schmidt's legal counsel to you?
Yes.
Do you feel like you've had enough time to talk with him about all of your cases so that you've had all of your legal questions answered?
Yes.
And you have signed a multitude of documents today with Mr. Schmidt's assistance. In signing these documents, did you put your true and correct signature and name in these documents?
Yes.
And did you only do that once you were confident you knew what and understood what you were signing?
Yes.
Is there anything about any of this paperwork today that you signed that you do not understand?
Yes.
Mr. Schmidt, do you believe Mr. Gurley to be competent to enter into a plea agreement today?
I do.
And have you explained to him his rights as they pertain to each one of his charges?
I have.
And you believe that he's intentionally, knowingly, and voluntarily entering into this agreement today?
I do.
All right, and it looks like there's 4 separate plea agreements. I'm just going to take them in order. In cause number CR 22-137, it appears that Mr. Gurley, upon a plea of guilty, the state would be recommending that to the charge of possession of child pornography, a 3rd-degree felony, that the state would be recommending to the court punishment assessed at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, along with a $2,500 fine, with the sentence imposed in this case to run consecutively with cause numbers CR 22-138, 139, and 140. And then the state would be asking the court to allow them to dismiss a multitude of other cases, including indecency with a child by sexual contact, and 6 other charges of possession of child pornography. In addition, a $2,500 fine plus court costs and reimbursement fees. And Mr. Gurley would receive 516 days credit towards the sentence and that cost for the time that he has spent in jail pre-trial. And it looks like in each case that the recommendation is the same for 10 years confinement in prison, also with $2,500 fines with all sentences running consecutively. And each case receiving the same amount of credit time in addition to fines, court costs, and reimbursement fees. Mr. Schmidt, do you believe that that constitutes the agreement that Mr. Gurley is seeking to enter into today?
Judge, I do believe that constitutes the agreement accurately. Also, it is my understanding based on the entry of this plea that all matters outstanding known to the examiners will be resolved today.
And is also a part of the agreement, the agreed protective orders filed in cause numbers FM 23, 39, 37, and 38.
It is the judge, and we've executed signatures on all those documents.
Okay. All right, Mr. Gurley, you've been charged by indictments with 3rd-degree felony offense of possession of child pornography in these 4 respective cases. The range of punishment for this type of offense is confinement of not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000. Do you understand the plea agreement as I've read it to be the plea agreement you've reached for the state? That's what you're asking the court to approve here today?
Yes.
All right, so Mr. Gurley in cause number CR 22-137, CR 22-138, CR 22-139, and CR 22-140. As to those respective cases and the respective charges of possession of child pornography, how do you plead? Are you pleading guilty to each one of these crimes because you are guilty of committing each one of these crimes?
Yes.
And has anyone threatened, forced, or pressured you to plead guilty to any of these crimes today?
Yes.
The court will accept Mr. Gurley's plea of guilt at this time. Mr. Schmidt, any objection to the state's evidence supporting each one of the causes in each one of the state's prosecutions?
No.
The state's one is admitted in each case respectively, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor. It's our understanding that the court has reviewed the victim impact statements that are relative to these causes. And we would ask that you take judicial notice on the record that you have reviewed this and return this back to the state.
The court has reviewed the victim impact statements, which have been provided to the court by the Van County Criminal District Attorney's Office. And the court will take judicial notice of the contents of that impact statement and will take it into consideration with the plea before the court today. Anything further from the state?
One additional thing, Your Honor, just wanted to make it on the record that the state has provided a copy of the Chapter 62 warnings to Mr. Gurley through his attorney.
We have received that, Judge, and Mr. Gurley has possession of it, we've been over it, as well as the admonishments contained.
Thank you, Mr. Schmidt. All right, record will reflect that a copy of Chapter 62 has been provided to the defendant with regards to the prosecution for a Chapter 62 law notice. Anything further from the defense, Mr. Schmidt?
No.
All right, Mr. Gurley, the court is going to review the evidence briefly. Counsel, can you approach? All right, the court has reviewed the evidence in each one of these causes. The court finds that there is sufficient evidence to support the conviction of Mr. Gurley for each one of the offenses. However, the court would like to inquire to counsel. The court understands that this specific type of charge carries with it some confidentiality and prohibition about disclosure of certain type of visual material concerning minors. Is there additional evidence that the state has given to the defense that is not being put before the court today in way of these public documents to support the plea agreement that the defense has received and could concede would support the defendant's conviction in each one of these causes?
Judge, during the discovery process, I did visit the state's office and did review the forensic evidence that was seized pertaining to the reference laptop and the materials that were submitted today. I also reviewed the chain of custody on the forensic analysis of the laptop computer, and the images that were submitted as an exhibit to the indictment were contained in that forensic document when I personally reviewed them. So at this point, I understand those are under seal, and subsequently why we didn't submit those as evidence, but I have reviewed them, and it would substantiate the finding.
Thank you, Mr. Schmidt. Anything further, Ms. Heisman?
No, Your Honor.
Okay. All right, then based on the evidence, the court finds that there is sufficient evidence to convict Mr. Gurley of this of these offenses. The court will follow the plea agreement reached between the defense and the state. The court hereby convicts Jeffrey Lance Gurley of possession of child pornography in cause numbers CR 22138, CR 22139, CR 22140, CR 22137. The court, and following the plea agreement, convicting Mr. Gurley of that offense, assesses punishment pursuant to the plea agreement at 10 years confinement in the Texas Department of Criminal Justice Institutional Division in each case respectively. Court fines Mr. Gurley $2,500 in each case respectively. The court orders that each sentence imposed by the court to run consecutively with other causes, CR 22137 to run consecutively with CR 22138, CR 22139, and CR 22140. The court takes into consideration under section 1245 of the Texas Penal Code, cause number CR 21384, indecency with a child by sexual contact, CR 22142, possession of child pornography, CR 22136, possession of child pornography, CR 22144, possession of child pornography, CR 22143, possession of child pornography, CR 22141, possession of child pornography, and CR 22145, possession of child pornography. Court imposes court costs of $290 in each case, reimbursement fees of $20 in each case, and the court awards Mr. Gurley 516 days credit for the time that he has spent in jail on this cause. And the court orders the time for each sentence to run consecutively with the other sentences imposed by the court today. Mr. Gurley, you are hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. But we ever, I'm going to ask that you take these to Mr. Gurley for fingerprinting. Families, this room. Over there. For the record, the court is also in cause number FM 2337, FM 23-38, and FM 23-39. Court is granting the agreed protective order as entered into the bond forms. All right, and Ms. Heisel, on behalf of the state, is there any victim allocution today?
Yes, Your Honor, we have MOJ, on behalf of the state, we would ask the board of allow her to allocate this time.
All right, Ms. Heisel, Mr. Shank, can you approach one more time? All right, Mr. Gurley, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. We'll take Mr. Gurley into custody at this time. David Pistol knows it's a sanctions court hearing. So the ring the Boaz warrant violation, but yeah, when you do it, I saw Brandon Boaz. 12 minutes, yeah. Jeremy Hester. Right. You better call those names.
Yeah, sure. He's going. I'm trying to do that.
All right, let the record reflect that the following names have been called loudly and distinctly 3 times in the courthouse with no response. They've not been present when the court called the docket or at any time in between. And the court is issuing judgment size for Randa Boaz, Charles Bennett, Jeremy Hester.
Interrupt on Jeremy Hester this morning by announcement was that Miss Parker had relayed that he would call COVID. I'd asked the court to take it under advisement 24 hours and allow me an opportunity to have him provide proof, medical proof.
Unfortunately, the court's going to deny that request. See Mr. Hester's failed report in January. A court will reconsider, Mr. Schmidt, if that you do get medical documentation supporting that claim. Court will consider withdrawing the NISA. Thank you. I believe that is all. So we'll issue NISA for those individuals. Court will stand in recess. It's 1 p.m. Court will stand in recess until 2 p.m. And we have Spanish interpreter at 2 and 2:30. So we'll start off at 2 o'clock and then we'll take a few and then we'll do the 2:30. All right.
I think the drill at 1:30 to 7.